Welcome to Kenya Laws Explained, your go-to podcast for unpacking Kenyan laws that shape our rights and freedoms. I'm your host, and today, we are diving deep into a fresh, game-changing ruling from the High Court in Nairobi. Just yesterday, on February 12, 2026, Justice Bahati Mwamuye delivered a landmark judgment that has everyone talking. The court has declared Section 95(1)(b) of the Penal Code unconstitutional. That's right. The old offence of creating a disturbance in a manner likely to cause a breach of the peace is now null and void. Picture this. For decades, police could arrest someone for simply speaking out, protesting, or even raising their voice in a way that disturbed authorities. No actual violence needed. Just the likelihood of trouble. That vague wording made it a favorite tool for silencing critics. But not anymore. This victory started with a petition filed by the Law Society of Kenya, LSK, the body that represents lawyers and defends the rule of law. LSK called this provision a colonial relic, a leftover from the 1960s era designed to protect British interests and later weaponized by post-independence governments to crush dissent. They argued it violated key parts of our 2010 constitution. Article 33 on freedom of expression, Article 52(n) on the principle of legality. Meaning laws must be clear and precise. And the broader Bill of Rights. The spark. The arrest of well-known political activist Morara Kebaso. On October 4, 2025, Morara attended a public participation forum at the Bomas of Kenya in Nairobi. The topic was heated. The impeachment of then Deputy President Rigathi Gachagua. During the chaotic session, Morara reportedly said the phrase "e kufa dereva, kufa makanga," a Swahili metaphor meaning if the driver dies, the tout dies too. Authorities interpreted it as incitement. 4 days later, on October 8, 2025, he was arrested and booked at Langata police station. They told him he'd be charged under Section 95(1)(b) for creating a disturbance likely to cause a breach of the peace. A misdemeanor that could land someone up to 6 months in jail. Morara was released on bond, but the case became a rallying point. LSK stepped in, arguing this law was being misused to target government critics, journalists, protesters. Anyone who made noise the state didn't like. The petition landed in the Constitutional and Human Rights Division of the High Court, where Justice Bahati Mwamuye presided. In his ruling, Justice Mwamuye didn't hold back. He described the section as broad, vague, and incapable of precise interpretation. Citizens couldn't reasonably know what behavior crossed the line, leaving too much power in the hands of police for subjective arrests. He pointed out the chilling effect. People hesitate to speak freely when they fear arbitrary charges. The judge echoed LSK's view that this was an insidious form of censorship, punishing speech that merely offended officials without meeting the strict constitutional tests for incitement or hate speech under Article 33(2). The court went further. It quashed the criminal proceedings against Morara Kebaso entirely, finding they were an abuse of the law to silence a whistleblower who monitors government projects and exposes corruption. The final words from the bench. A declaration be and is hereby issued that Section 95(1)(b) of the Penal Code is inconsistent with the Constitution and is therefore unconstitutional, null and void. Justice Mwamuye ordered the National Police Service and all law enforcement to stop enforcing it immediately. Why does this matter so much? In real life, this ruling frees up civic space. Activists can now attend forums, criticize policies, or film public projects without the constant threat of a vague disturbance charge. Journalists covering protests or scandals face one less tool of intimidation. Everyday Kenyans arguing in a market or neighborhood won't be hauled in on flimsy grounds. The youth will not be arrested for just hanging out on the streets. Police must now rely on clearer laws, like those for actual incitement, rioting, or violence. Reducing overreach, especially in informal settlements or during youth-led demonstrations. Of course, other public order laws remain, so this isn't a free-for-all. But it's a major step toward decolonizing our legal system and living up to the 2010 Constitution's promise of transformative justice. This is a win for freedom of expression, for whistleblowers like Morara Kebaso, and for every Kenyan who values open debate. As Justice Mwamuye reminded us, in a true democracy, the right to criticize the government is sacred, as long as it doesn't cross into real harm. That's it for today's episode of Kenya Laws Explained. If you're in Nairobi or anywhere listening today, celebrate this one. Share your thoughts. What does this change mean for you? Drop a comment or voice note. Until next time, stay informed, stay bold, and keep holding power to account. This is your host signing off. Asantini sana.